Good evening and welcome to this evening's Legal Hour on Ben TV. My name is Raheela Hussain and I am from Greenfields Solicitors. I am the Principal Solicitor of Greenfields Solicitors. Greenfields Solicitors are a firm of specialist immigration and human rights solicitors. I am 13 years post-qualification experience and I specialise only in UK immigration and human rights law. I would like to invite our audience to call in with any questions they have on immigration law. The number to call for a live call discussion with myself is 0208 808 0693. This is a live show. Please note that the information I provide on this show is not to be taken as legal advice, but is just general information to assist our members of the audience and our Ben TV audience with regards to their immigration questions. The number again for you to call the line and to speak to me directly is 0208 808 0693. Now, as an introduction to this show, I would like to talk about the recent changes that have occurred in immigration and human rights law. On 6th of April 2015, the Home Office introduced something called a health surcharge. The health surcharge seeks to raise 200 million a year for the government, and effectively the way it works is where an application is made by a migrant for entry to the UK or where they seek leave to remain in an extension application or any category within the UK, then they will need to pay a fee of between £150 to £200 in addition to the Home Office fee in order to have their application processed by the Home Office. Currently, the Home Office is seeking to recover a fee of 1.7 billion, which it feels it has lost due to NHS treatment being taken without due process by migrants in the UK. Another recent change that has occurred is with regards to sham marriage clampdowns, which represent a massive problem for the UK government. Under the current regime, the notice period for marriage and civil partnerships is 15 days. However, effective from the 2nd of March last month, it is now important for a person to provide 28 days notice to a marriage registry in order to marry. Where the marriage registry suspects a sham marriage, then they can take up to 70 days in which to investigate before they allow a couple to marry. Finally, it's also important to notice that the immigration applications have been updated on the Home Office website. This occurs every Easter bank holiday, most commonly. And on all of the new immigration applications that were published on the 6th of April of this year, it is now important to provide either a current and original passport, a national identity card, or a travel document for a migrant in order for them to make a valid application to submit to the Home Office. The Home Office are stating that without a valid current passport, a valid ID card, or a travel document, they would be unable to process an immigration application. Obviously, this will have serious consequences on people who do not have a current passport, ID card, or travel document. However, in the immigration applications, there is a section whereby if one is unable to provide any of these documents, then the Home Office will consider an explanation. For example, if you do not have a passport because you have lost this, then perhaps you can obtain a police report or any other documentary evidence which would satisfy the Home Office as to why you do not have the relevant documentation in order to progress an application. The Home Office can then consider this explanation and still progress an application. Now, on this evening's show, I'd like to discuss a very, very popular topic and something that I face on a day-to-day basis in my practice as a solicitor. We receive a number of calls from members of the public who are concerned because they have issues of being an overstayer. I would like to invite people who have questions on immigration, particularly with regards to overstayers, to give me a call on 0208 808 0693 for me to provide some helpful information with regards to them perhaps obtaining lawful and legal status in the UK in regards to regularisation of legal status. So what is an overstayer? An overstayer can be defined as somebody, a migrant, who has entered the UK with a valid visa, be it a visit visa, a Tier 4 student visa, a Tier 1 entrepreneur visa, or indeed any visa category. And subsequently, they have overstayed the visa. So at the end of expiry of that visa that was issued to them, they did not return to their native country, but they chose to remain in the UK for whatever reason. Such people are coined as overstayers. In addition, there is a definition and there is a difference between the term illegal entrant. An illegal entrant is somebody who has entered the UK clandestine, which means they have entered without any visa, unlawfully. Commonly, what we see in practice are people who enter the UK with the back of lorries or through illegal means, and they have no papers or no means of entry. They are not the same as overstayers, so the two terms should not be confused. The subject of overstays is particularly prevalent in the African community. We face on a day-to-day basis a number of clients who have entered, say, on a visit visa, a Tier 2 visa, a Tier 4 visa, spouse visa that's broken down, and subsequently they have no basis to remain here, but they do not seek to return to their home country. As such, what we seek to do is make an application for these migrants to regularise their legal status in the UK on the basis of their circumstances. So, for example, if a migrant came 5 years ago, 4 years ago, however many months ago to the UK, and they overstayed their visa, and they did not wish to return back to their home country, then they may submit an application to the Home Office to explain the reasons why they do not wish to return to their home country. These circumstances may include the difficulties they face if they go back. Perhaps they have no assets. Perhaps they have no family in their home country. Perhaps they have no ties or means of support. And perhaps in the UK they do have that level of support. It could be that the migrant person, whilst their time in the UK, has established a family life, has many friends, colleagues, obtained employment, obtained skills, education or qualifications, which would make it desirable in order for them to remain in the UK. Commonly, overstayers may seek to make an application for regularisation of legal status, and the kind of status they would request is often called discretionary leave to remain. Now, discretionary leave to remain, if successfully obtained by an overstayer, will allow the migrant a period of 2.5 years initially to live, to work, to study, effectively to become a lawful member of British society. Often this is what people desire the most, to have some sort of lawful status and legal residence in the UK, often after a many number of years where they have remained illegally or unlawfully. So, in practice, the kind of situations that we come across are, for example, a lady from Nigeria enters the UK in 2006. She overstays a 6-month visit visa. She seeks not to return, and therefore she effectively wants to make an application for regularisation of legal status. At the moment, I will take a call that we have coming in, and I will return to the point of the case scenario I have. Hello, caller.
Yes, hello.
Good evening.
Yes, good evening. Right. As an overseer for the past 20 years.
Yes.
What the Constitution says now that without any ID, no passport, nothing to support my application. What else can I do? Because, been in the country for the past 20 years. And
have you attempted to make an application before, sir, to the Home Office?
I think I tried. That was 1998 or something. Yeah.
Many years ago. Do you think it's possible for you to obtain a current passport from the embassy here in London or in the UK at all?
To be honest, even then, the passport, I lost the passport, 8 years ago. And when I made the application in 1998, we couldn't trace the passport. But I came, I literally, with 6 months visa. That's it.
So if you feel you can't get a current passport from the embassy in the UK, if you feel you can't get an ID or travel document, it would seem that the Home Office will not process the application. However, what I would like to say to you is that this is a very, very recent change. It only occurred a number of days ago on the 6th of April. So obviously there are going to be many, many people like you, if not in the thousands, who are in the same position and should not be in any way suppressed to make an application for regularisation of legal status. I dare say solicitors and barristers will all come together and perhaps bring a judicial review action against the Home Office, because as you may know that for many, many years they did not require these documents in order for somebody to make an application for lawful status. So at this stage, because the change is very new, I can't say to you definitively what you can or can't do, but I would say keep your eyes peeled, because very shortly there will be a collective agreement between solicitors and barristers who potentially will bring a judicial review action against the Home Office for discriminating. Effectively, we can say this is a type of discrimination, and that the Home Office do not wish people to regularise their legal status. Now, in a country such as the UK, which has a very fair legal system, this is unacceptable. So I would say to you, just keep your eyes open for our Home Office updates, and certainly on Greenfields Solicitors website, we do provide very, very frequent Home Office updates that you can keep your eyes on. But at this stage, unfortunately, without the current documents required, the Home Office will not progress the application. Okay, thank you very much for your call, sir.
All right, thank you very much.
Thank you. So going back to the issue of the lady in the scenario who entered the UK on a visit visa and subsequently overstayed, she may have during this time in the UK had a partnership with somebody. So she's since had a partner, she's had a child perhaps, and the partner is holding some sort of legal status, be it indefinite leave to remain, British nationality. And by virtue of the child being born in the UK to a parent who holds indefinite leave to remain or British nationality, then effectively the child will also be potentially eligible to have a British passport. In such circumstances, the migrant lady can then make an application for leave to remain on a discretionary leave to remain basis to the Home Office, and she can argue the human rights factors in her case. These being that she has a partner who's present and settled in the UK, has a child born and settled in the UK, and that it would be fair to allow her leave to remain in the UK with her family members. Now, in practice, I can tell we deal with hundreds of these type of applications. Many are deemed successful if it can be shown that there is a genuine partnership relationship between the settled partner, and especially if there are any children of the family. The UK government are particularly open and pro-children's rights, and therefore, if the migrant has a child in the UK, we would very much process such an application, because we know with our experience such applications are accepted and considered very highly by the Home Office. This does not deter from the fact that there are those who have not established a family or private life in the UK or do not have children. So there are many, many single people who have been here but still wish to make an application for regularisation of legal status. In any event, it's always a good idea, and we always say to people, you should make an application, you should try to abide by the terms and the laws of the UK and submit an application to regularise your legal status. It's extremely important to comply with the laws of any country, to make every effort to try and fit into the social criteria and to show that you are trying to comply with UK immigration laws. Now, another popular topic that we come across with regards to overstayers are not such that they become overstayers, but there are those who are nearing the end of their visa. So again, somebody on a visit visa or a Tier 4 visa or a spouse visa. And effectively, they wish to remain in the UK and they don't wish to go back at the end of their visa. In such circumstances, what they need to do is consider, well, on what basis do they wish to remain in the UK? Often in practice, I come across clients who say, we don't wish to return to Nigeria or Kenya, or we don't wish to return to any country in the world, indeed. We wish to settle in the UK and make this our home, even though we've been here for a short period of time, 2 years, 3 years, or even 10 years, we consider the UK our home. So what is always a good idea is for that person to consider making an application before expiry of their visa, applying for something called a variation of legal status. So it's not regularisation of legal status, but rather it's called variation. The reason why it's called variation is because the person currently has a valid visa and they are trying to effectively vary their visa to another legal status, specifically discretionary leave to remain. Now, it could be that the migrant shouldn't necessarily consider discretionary leave to remain as the correct visa, but rather they can consider that there are other visa options available. For example, they may be eligible to apply for another tier points-based system visa or a spouse visa, depending on their circumstances. So it's always a very good idea to obtain firm, legal and accurate legal advice with regards to what avenues are available to a person to try and remain lawfully in the UK. The UK immigration authorities appreciate and acknowledge those who try to make an effort to regulise their legal status sooner rather than later. And indeed, I can tell you as a solicitor, by making an application when you have legal status in the UK, while you have current visa, makes the entire immigration application a lot easier, a lot smoother, and often a lot more profitable for clients. For example, if an application is made whilst a person has lawful status, so they currently have a visa, then effectively, even if the Secretary of State, for argument's sake, refuses an application for variation of legal status to discretionary leave to remain, they should have been granted an in-country and immediate right of appeal in the UK. The law works as such that where a person makes an application for legal status of any type and they have current legal status, and where an Article 8 or any human rights argument is raised, then they tend to have the option of appealing a decision if it is refused by the Secretary of State in the first instance. At appeals, an immigration judge will be present. Also, the migrant can have a barrister to represent them, along with the respondent, which is often the Home Office, who will be at the court and trying to argue that the Secretary of State was correct in their decision. Now, if the Secretary of State refuses a case for discretionary leave to remain, then this will be provided in a reasons for refusal notice. In a reasons for refusal notice, the Secretary of State should ideally consider the circumstances the person provided when they made an application for discretionary leave to remain. They should then address why the case has been refused with reference to the relevant immigration rules, laws, and relevant immigration case laws. Now, immigration law is changing on a day-to-day basis. There are so many changes in immigration law, it's often difficult for even practitioners to keep up with the many, many changes. The Home Office take a number of days to update the Home Office website, and therefore it's not always clear as to what the new change is. I always suggest to those who are looking to make an immigration application or to obtain legal advice that they should effectively obtain the advice and services of professional solicitors who specialise in immigration and human rights. I believe we have another call in line. I'd be happy to take that call. Hello, caller.
Hello.
Good evening, madam. Hello.
Yes.
Hello, how can I help?
Yes. I said I'm speaking on behalf of somebody. I'm Jumoke.
Okay.
So somebody is a friend of mine.
Yes.
I've been here 25 years now.
5 years. Mm-hmm.
And he put application in year 2004. Then
Right.
he gives her. After on again, they apply again. And they say they refuse. Later on again, they say they keep empowering to apply.
Madam, could you just please speak up? Your volume is just a little low in the studio. If you could please speak up for me. So they refused her application?
They refused it. And later on, the second time, they say the third one, they say he has priority to appeal.
Right.
So now, but they didn't give him any appeal. They just sent 2.5 years to her. And they say she should go and work, which is 67 years old now.
So she's been granted the discretionary leave to remain. Is that right for the 2.5 years?
They're giving the 2.5 years.
Yes, so that would appear that they have actually granted her discretionary leave to remain, which allows her to remain lawfully in the UK.
Yes, they say she should remain for 2.5 years. So maybe later they can...
Okay, just to let you know, usually when they grant the 2.5 years, the person can then extend that every 2.5 years. Okay, so you need to look at the letter that was issued with when the Home Office approved her case. They would have sent a letter with the biometric residence permit, and on that letter it will state when she can apply for indefinite leave to remain. Usually with discretionary leave to remain, there are two main routes in order to apply for indefinite leave to remain, which many people consider as being permanent status. It's after either 5 years or it's even after 10 years.
No, they have been here since 25 years.
Yes, with discretionary leave to remain application. So we're clear. What your friend, how many years has she been in the UK, madam?
25 years.
Okay, and all right. So the reason that the Home Office more than likely gave her discretionary leave to remain is because in July 2012, the Conservative government changed the immigration law. As you know previously, or many of our viewers do know, prior to this, after 14 years, it was possible to obtain indefinite leave to remain in the UK. However, since July 2012, the law changed. The 14-year law was abolished. And they said, after you have been here 20 years, you may then make an application, but we will only grant you discretionary leave to remain. We will not grant you indefinite leave to remain. So therefore, that's why people are granted 2.5 years, and they have to extend it either to 5 years or 10 years and then be eligible to apply for indefinite leave to remain. Okay, thank you for your call, madam.
Oh, that is, but I've already spent 25 now, but it's supposed to be qualified for the 20 years, isn't it?
It's discretionary leave after 25 years.
20 years, yes. It's 25 this year.
With regards to the immigration applications made by migrants to the Home Office, there are probably millions of applications, I should say more in the region of 100,000 plus applications, actually, to be more factually correct, every year to the Home Office. Now, at the moment, the Home Office has taken up to 4 months to process applications, which is quite a quick turnaround. Once an application is lodged to the Home Office, in approximately 2 weeks, an acknowledgement letter will be sent to the migrant, and thereafter, after maybe another 1 month, they will then send a biometric enrolment letter, which requires a migrant to go to a local post office and to provide their fingerprints. The reason the Home Office recently introduced this is to avoid fraud and to ensure that those who are applying are genuinely applying, and also to catch out those who have previously made applications in another person's name, in an assumed identity, and to generally make sure that they have an eye on migrants who are applying for leave to remain. Thereafter, one can expect a decision within 3 months. As I said earlier, where a person is granted discretionary leave to remain, they are granted 2.5 years initially. Thereafter, that person can then extend the discretionary leave to remain, and this can be either for a 5-year period or 10-year period, depending on the route of which they applied. Now, for the 5-year period, usually one can apply for indefinite leave to remain if they have a British child, if they are a carer of a British child, or if they are a partner of a settled person. However, the 10-year route is available to those who have established a private life, so perhaps they do not have children, but they have established some other compelling, compassionate or exceptional circumstances which allow the Secretary of State to grant them leave to remain in the first place. The subject of overstays is very huge. It's a very varied subject. It's very diverse. The laws are continuously changing and evolving. And it's extremely important to know the relevant laws at the time. I cannot express to you how many times I have had people call me and they have told me I wanted to save money on legal fees and Home Office fees, and I made the application myself. I'll go back to this topic as we have another caller, so I'll just take that call. Good evening, caller.
Yeah, good evening. My name is Emmanuel.
Hello, Emmanuel.
Yeah, I'm just asking that my visa.
Yes.
I just overstayed, and I made another application. So I don't know, maybe I could fall under the same rule, the 28-day rule.
Sure. When did your visa expire, Emmanuel?
On Friday, on the 10th.
Oh, that's a shame. Just very recently.
Yes.
And when did you submit the application to the Home Office?
I paid a same-day application on the same day it's meant to expire.
Okay. Was that on the online system?
The online system, yes.
Sure. What did you apply for, Emmanuel?
Leave to remain as a parent of a British child.
Okay, well that's interesting. How old is your child, Emmanuel?
It's just 10 months.
Okay, do you live with the mother at all?
No.
Okay, but you have access to the child?
No, officially, no.
You don't see the child?
I do see him, but no, as in, I didn't go to court to go and,
Get a contact order. Okay,
affidavit or anything.
that's fine, Manuel. I can tell you many of our clients do not have contact orders or access orders. The Home Office, what they actually look at is whether you indeed have a parental relationship with that child.
Okay.
So as you know, a court order doesn't necessarily mean whether somebody has involvement with their child. That can be established in many other ways, such as you may see your child, you may have photographs, you may financially contribute, maybe you have a letter from the mother confirming that she's happy for you to continue playing a role with the child.
Okay.
I don't know what kind of documents you obviously submitted. Did you submit your original passport or anything like that?
That's going to be when I go in for the interview. I've already been scheduled for the interview, which is this week.
Okay, so all right. Well, I don't think you should be so concerned at the moment. From what you've said, you've put the application in before your visa expired.
Yeah.
As you know, the visa would have expired at midnight on the day, so
Yeah.
you put it in advance.
Yeah.
It seems like your application is progressing as you have been asked to attend a Home Office interview.
Yeah.
And as I've mentioned, one doesn't necessarily need a contact order or residence order. The Home Office will look at a whole array of circumstances before they grant leave to remain. Are you obtaining legal advice?
No.
Okay, it may be a good idea for you to obtain legal advice. That's what I would suggest to you. Okay, Emmanuel?
Okay.
All right, thank you for your call. So going back to the point of not, as we've just learnt there from Emmanuel, making your own immigration application, because one could be very worried, very anxious, without legal counsel, without knowing the immigration rules and the case laws. It's a difficult thing for anyone to do, let alone a person who's not from the UK, who's unfamiliar with the immigration systems. Now, the immigration forms, and perhaps this is a little controversial what I'll say,